the blood price. In recent years, articles concerning incidents in prison and a fallible system have been plentiful. They have been brilliantly composed by editors, attorneys, private citizens, and the like. One such article that appeared in the not-too-distant past was "The Price of Innocence" by attorney Terry Gilbert in the Cleveland Plain Dealer, June 1st, 2010. Evidently, he had formulated this column in the bright light of Raymond Towler's release. As a casualty of a grievous injustice, it is easy for me to emphasize with Mr. Towler and concur with Mr. Gilbert's astute insights, some of which I desire to expand upon in regards to his fallible system and my own actual innocence as well. Hopefully, this will provide an insider view of corruption and injustice, a view that is seldom entertained. Currently, I am incarcerated for the bogus and insolent charges of rape and gross sexual imposition. At the moment, I am in my 5th year of incarceration and I have fought the epaulet battles with dignity and zeal. In the course of petitioning nearly 30 different state, local, federal, and private entities with proof of actual innocence from the face of the trial record, I've had 4 appeals denied while one court ruled as if my innocence does not matter. In his article, Mr. Gilbert had mentioned how appeals are constantly denied by the courts, which hate to recognize that a witness or jury could be mistaken. This is a result of a foolish pride. Further, if a pro se litigant is defending a sex case, the defendant is automatically prejudiced, deemed a leper, then self-righteously discarded as yesterday's refuse. My conviction truly goes against the grain of the rudimentary principles of the judicial system as it was founded and formulated by the framers of our U.S. Constitution. There are no eyewitnesses to the allegations. There is an intact hymen with no abnormalities. And above all, no DNA to either support or sustain a conviction. Amazingly enough, the judicial system does not require DNA to convict, but demand it for a post-conviction acquittal. But woe to the man who needs it to prove his innocence. In regards to such, Mr. Gilbert wrote, how many of them are innocent, like Raymond Towler, but have no DNA to prove otherwise. Even a small percentage is unacceptable. I am a part of that unacceptable percentage. One moment I am basking in the sun, running a successful construction company, and the next I am dashed against the rocks of despair as a fallible statistic. With fervor, I applaud Mr. Gilbert's statement where no one should be convicted on the testimony of one eyewitness. Such evidence is frail at best and mistaken at worst. Any Webster's dictionary will verify that to witness means to see and not to hear. And say is a hearsay, and say as in hearsay testimony. Even the scriptures declare that one witness shall not rise up against a man for any iniquity. At the mouth of 2 witnesses, or at the mouth of 3 witnesses, shall the matter be established. Deuteronomy 19:15, a solid study of the ancient Hebrew culture, and one will thoroughly understand that this was ordained and written for eyewitness testimony, and not hearsay witnesses. In this light, 13 witnesses testified at my trial. Outside of 2 alleged victims, 11 were hearsay witnesses. They merely told varied versions of the same story that they have heard from the alleged victims and each other. As the hearsay witnesses' testimonies were often in conflict, they were completely contradicted by the alleged victims. During trial, the alleged rape victims' manipulated and coerced pre-trial statements were completely rendered null and void by her voluntary in-court testimony. She testified that 2 days prior to her 10th birthday, which was Sunday, that it really hurt in her private while she spent the entire weekend with her dad in Put-in-Bay celebrating and not at Frank Wood's house. As I was indicted, tried, and sentenced in Medina County, Put-in-Bay is in Ottawa County, a place I have never been. Not only whereabouts on the indicted testified to and confirmed dates of abuse verified by both of her legal guardians, the prosecutor confirmed this testimony as having no evidence to the contrary. None. The alleged gross sexual imposition victim's testimony functioned in the same contradictory manner. During her voluntary in-court testimony, she twice verified that the crime never took place at all. The trial court, as supported by the record, conceded this as fact and declared, "What I'm hearing her say is, no, it didn't happen," with proof of actual innocence resting at the heart of the alleged victim's testimony. The axiomatic standard of reasonable doubt has not only been surpassed, it has been shattered. But the jury chose to convict on hearsay testimony and paid little or no heed to the truth. Prosecutors come on strong, vouching for utilizing the lack of physical evidence as evidence and declare, "You wouldn't expect to find any physical evidence after all this time." They do the same by declaring exclusively before the jury that hearsay witnesses' testimony is cold hard evidence. Evidence you get to see, evidence you get to judge, evidence you get to interpret. Prosecutors do all they can to build a case in pompous attempts to turn a myth into fact. They use a lack of evidence and hearsay testimony to paint a picture and sway a jury to convict by convincing them that the defendant is a bad person and deserving of some sort of punishment. To a jury, if enough people say it happened, then it must be true, regardless of the fact that the witness is only reiterating a story and never saw anything. The DNA or a recanted statement comes along and proves a man innocent after years of unjust suffering and penury. Prosecutors defend their wrongs and failures arrogantly by declaring every now and then one slips through the cracks, or "You have to break a few eggs to make an omelet." No apologies, only prideful, defensive remarks. As they display no sign of repentance or reflection, they lack moral courage, the greatest of all courages, and refuse to admit they were wrong. During the course of trial, after a curt exchange of words, my lead counsel did call one witness to the stand, Dr. Douglas M. Reed, Ph.D., a licensed clinical psychologist of 13 years' experience out of Mason, Ohio. Dr. Reed has spent his entire career working with sex offenders and psychopaths and developed the STOP program for the state of Ohio, a program designed for sexually-oriented offenders leaving prison. In open court, this is what he declared. He has none of the typical drives that a pedophile would have or the typical abuser would have toward minor children. His sexual behavior inventory shows that he has normal, healthy sexual thoughts. His preferences are heterosexual. He has sexual attraction to adult women. He's not sexually compulsive or addicted. In my professional opinion, his sexual behavior is under control. He is not out of control. Compulsive. He's above average in intelligence. In my personal opinion, Frank Wood does not meet the diagnostic criteria for pedophilia. He does not endorse or agree the 3 core beliefs or rationalizations used by pedophiles to justify their behavior. Everything he believes would be violated if he were to touch a child sexually. As belief determines behavior, Dr. Reed has unbiasedly and scientifically proven that I could not possibly psychologically achieve committing such heinous acts. His testimony not only corroborated both the alleged victim's voluntary in-court testimony, it solidified my actual innocence, as I was neither permitted to testify nor present witnesses and or evidences before the jury. Dr. Reed was only permitted to speak voir dire. The jury never heard any evidence on my behalf. After being dismissed from the stand, Dr. Reed stated that this was the first time that he was not permitted to testify. Although the record reflects that my case was closed twice, it still became a witch hunt. The investigation was so reckless and cavalier in nature that it was basically point the finger and go. Why? A crime may or may not have been committed, and someone had to pay the blood price. And it didn't matter who. Such is the true price of innocence. My conclusion of cause is verified by Dr. Gilbert's intrinsic insight. A juror's natural instinct is to nail the guy on trial. The law may declare one innocent until proven guilty, but in a juror's mind, one is guilty until proven innocent. A jury is lacking in knowledge of the law and relies on past episodes of Cold Case or LA Law. They wait for the surprise witness to walk up and dazzle the courtroom, or for Dr. House to appear and clear everything up in 60 minutes. To compound the situation, anyone accused of a sex crime can be sent to prison via jury trial solely because of an alleged victim, a hearsay witness, or a prosecutor merely pointed a finger in silence. To a jury with, as a trial court declared, a cynical attitude, my fate was sealed before the trial even began. In a system that requires, by operation of law, a judge to view the evidence presented in favor of the prosecution. In a state where courts are paid per conviction, the presumption of innocence is as fraudulent as constitutionally fair trial. There is another facet to this fallible system that is often overlooked or ignored. One that I experienced firsthand: revenge. With the right amount of money, anyone can utilize the system as an instrument of destruction or a weapon of revenge. Prosecutors become executioners of wrath with no moral conscience. They will ask the same question 10 different ways to get the answers they want to hear. They work the witnesses with leading questions and then present their versions of the manipulated myth as fact to the jury in closing arguments, often with no chance for rebuttal. An angry man, the right amount of money, and a prosecutor looking to advance their career is all it takes to generate this wicked maelstrom. It wasn't until my lead counsel informed me that my case was closed twice and asked me, "Who has enough money to reopen your case?" that everything began to make sense. Money and a motive accomplished much. Yes, I know how the charges developed, where they came from, and their intended purpose. They can relish in their dishonorable victory for now and hide from their sins. But there is a God in heaven who decreed, "Be sure your sins will find you out." Deuteronomy 32:23. What has been presented thus far probably sounds like a gripping miniseries from Hollywood, but unfortunately, it is our justice system. A system that is in dire straits and in desperate need of reform. However, as Mr. Gilbert pointed out, those who seek meaningful reforms and perhaps avoid injustices like Raymond Towler will be met with resistance. Why? The $68 billion prison system is actually an industry. Recent studies verified that 25% of the world's prisoners reside in the U.S. prisons. An estimated 24 to 26% of those incarcerated are actually innocent. Therefore, this industry has a product that makes it marketable, and there are buyers. As long as laws are written too loosely and not in accord with the U.S. Constitution, in order to obtain convictions, and courts, prosecutors, and police continue to act as autonomous communities, you or one of your loved ones could be the next stock opinion. Remember, false imprisonment can happen to anyone at any time for any reason. I am Frank P. Wood. Frank P. Wood, inmate number 504-107, Grafton Correctional Institute, 2500 South Avon Belden Road, Grafton, Ohio, 44044. I am Frank Wood's little brother. If you have any questions, please leave them on YouTube or contact me via email at platinumdarkness@aol.com. Thank you.